Law school teaches you how to read documents. It mostly does not teach you how to write them. You spend 3 years learning how to dissect a contract, pull apart a complaint, and identify what's missing in a brief. Then you graduate, walk into your first job, and a partner drops a stack of documents on your desk with some version of, "Use this as a model and draft something similar by Friday." That moment is where most new California attorneys realize their legal education has prepared them to critique documents far better than to produce them. The good news is that real-world legal drafting is a learnable skill, and it gets dramatically easier once you understand what is actually expected. Here is what law school left out, and how to close the gap fast. The skill gap is real, and it's not your fault. Legal writing courses tend to focus on memos, briefs, and the occasional client letter. Those are valuable, but they represent a tiny slice of what most attorneys actually draft. In your first few years of practice, you are far more likely to be drafting complaints, answers, cross-complaints, demurrers, motions to compel, motions for summary judgment, and proposed orders, settlement agreements, releases and stipulations, commercial leases, purchase agreements, employment agreements, NDAs, and operating agreements, wills, trusts, advance healthcare directives, and probate petitions, discovery requests, deposition notices and subpoenas, engagement letters, fee agreements, and conflict waivers. None of those documents are taught in detail in most law school curricula, and the ones that tend to be taught at a conceptual level rather than a drafting level. There is a real difference between knowing what a motion to compel is and being able to draft one that complies with the California rules of court, the local rules of your specific superior court, and the unwritten preferences of the judge assigned to your case. This is not a failure of legal education so much as a feature of how the profession is structured. Law school teaches the analytical foundation, practice teaches the craft. The transition between the two is where most new lawyers struggle, and it is also where the lawyers who close the gap quickly start to stand out. Strong legal drafting is not about sounding smart. It is about producing a document that does its job, withstands scrutiny, and does not create new problems for your client. A few things separate competent drafting from amateur drafting. Precision over flourish. New attorneys often try to make documents sound impressive. Experienced attorneys focus on making documents unambiguous. If a clause could be read 2 different ways, you have written it badly, no matter how elegant it sounds, anticipating what could go wrong. A well-drafted contract is essentially a list of decisions made in advance about what happens if something breaks down. The attorneys who draft well are the ones who can imagine the dispute before it happens and write the document to resolve it, knowing what to keep and what to cut. A lot of legal drafting is editing rather than writing. Boilerplate that does not apply to your situation is not just useless, it is dangerous, because it can create obligations or rights you did not intend. Every clause should earn its place, following the local rules. California is not one jurisdiction. It is 58 counties, each with their own local rules, their own filing quirks, and their own judicial preferences. A motion that is perfectly drafted for Los Angeles Superior Court may need real adjustments before it is filed in San Francisco or Sacramento. Pretending this is not true is a quick way to annoy a judge. Getting the form right. Judicial council forms, county forms, and standard pleading paper requirements are not optional. Filing the wrong version of a form, or a form that has been updated since you last used it, can get your document rejected before anyone reads the substance. Drafting is one of those skills that improves dramatically with deliberate practice and barely at all with passive experience. Here is what actually moves the needle. Read good documents constantly. When a senior attorney sends you a draft, do not just sign off on it. Study it. Notice what they kept short, what they expanded, what they organized into headings, and what they cross-referenced. Build a personal library of the documents you find well drafted and refer back to them. Reverse engineer the document before you start. Before you draft a contract or a motion, sketch out what the document needs to accomplish, what the other side will likely push back on, and what the worst-case scenario is. The drafting goes much faster when you know what you are trying to build. Use templates intelligently. Templates are tools, not crutches. Starting from a strong template saves time, but only if you actually understand each provision and adapt it to your matter. The lawyers who get in trouble with templates are the ones who never read past the first page. Get your work redlined and study the changes. When a partner returns a draft full of edits, that is the most valuable feedback you will ever receive. Sit with it, figure out why each change was made. Patterns will emerge, and your next draft will reflect them. Learn the local rules of the courts where you practice. Bookmark them, read them, refer to them every time you draft something for filing. The local rules contain answers to questions you did not know you needed to ask, like font size, line spacing, page limits, hearing reservation procedures, and chambers copy requirements. Keep a personal style guide. As you encounter useful clauses, helpful turns of phrase, and standard recitals that work well, save them. Most experienced attorneys have a private collection of language they have refined over years. Start yours now. One of the fastest ways to accelerate your drafting is to work from documents that have already been vetted by experienced California attorneys. Starting with a blank page is romantic. It is also slow, and it tends to produce inconsistent results when you are still developing your instincts. CEB's Standard Documents Library, available through the practitioner platform, gives California attorneys access to high-quality templates, forms, and standard clauses across a wide range of practice areas, including business law, real property, employment, litigation, family law, estate planning, and emerging areas like privacy and cybersecurity. Each document is downloadable in Word, with the option to include or exclude guidance comment annotations. Those guidance comments are what make the resource genuinely useful for newer attorneys. They are not just templates. They are templates with built-in explanations of what each provision does, when to adapt the sample language, and why an alternate clause might be a better fit. You are essentially drafting alongside a senior California practitioner who is showing their work. For attorneys who also need to file judicial counsel and county-specific forms, CEB's Essential Forms product handles that side of drafting with automatic updates that often arrive weeks before forms are publicly released. Together, standard documents and essential forms cover most of what a California attorney actually drafts day to day. Drafting well is one of the most valuable skills a lawyer can develop. Clients can usually tell when a document was thrown together, even if they cannot articulate why. Judges definitely can. Opposing counsel definitely can, and the cumulative effect of years of strong drafting is a reputation that opens doors, attracts clients, and makes every step of your career easier. Law school gave you the foundation. Practice gives you the craft. The lawyers who treat drafting as a skill worth working on rather than a chore to get through are the ones whose work product starts to stand out within their first few years. Start building that reputation now. Looking to sharpen your real-world drafting? Explore CEB's Standard Documents for California-specific templates, forms, and clauses with expert guidance comments, available through the practitioner platform.